All rise. The United States Navy Marine Corps Court of Criminal Appeals is now open and in session. God save the United States and this honorable court.
Please be seated. Good morning. Are counsel ready to proceed in the case of the United States versus Wood?
Yes, sir.
Before we proceed, let me just make sure that all of our paperwork is accurate. The appellant filed a consent motion to attach photocopies of photographs on the 16th of December. My records reflect that motion was granted by the court on 17 December. Is that accurate?
Yes, Your Honor.
Then, in addition, the United States filed a motion on the 17th of December, a consent motion to attach documents, which is an affidavit from a, I can't pronounce the person's last name, but it looks like it was a trial counsel from the case.
Yes.
That motion has not been acted on at this time, so what I will do is grant that motion for the records. All right, counsel, you may proceed.
May it please the court. My name is Captain Jeff Liebenguth, and I represent the appellant in this case, Private First Class Jeremy Wood. Senior Judge Disney, with your permission, I'd like to reserve 5 minutes of my time for rebuttal.
Certainly.
Regarding the appellant's first assignment of error, not only is the evidence factually insufficient to prove that Ms. T was incapacitated or did not consent, but the evidence actually points to her being an able, willing, and responsive sexual partner. In understanding how Ms. T wound up in 29 Palms and in appellant's barometer is crucial in this case. Ms. T was vacationing in the resort town of Palm Springs. She met up with a friend, and since there were no parties going on in the Palm Springs area, they decided to go to 29 Palms, the Marine barracks there, and hang out with Marines. And not just any Marines. They went there to hang out with male Marines. In fact, unlike the resort town of Palm Springs, 29 Palms is in a desolate area. There's little else between the two cities other than desert. The only reason for two college-age girls to drive 2 hours to 29 Palms would be to meet and hang out with guys.
Counsel, the court is versed in the facts.
Yes, Your Honor.
Please proceed to the assignment of error first.
Yes, Your Honor. Well, and it is critical, Your Honor, if I may, if this court gets to whether it's reasonable for PFC Wood to have thought that Ms. T was consenting, to know what he saw on that evening. And so when they arrived at 29 Palms, they joined Ms. T in Lance Corporal Benson's room. This is around midnight. Ms. T fixes herself a drink. She notices appellant, and she sits down next to him. And apparently they hit it off. They talked about school. They were both interested in psychology. And the appellant said that she certainly seemed interested in him. And at some point, they actually leave the room. They go out on the catwalk, and they're hanging out. And he says that they're hugging. They're putting their arms around each other at some point. And she actually kisses him.
Counsel, is that statement corroborated by any other evidence of record?
No, Your Honor. This is the appellant's statement to NCIS. Now, within an hour of arriving at 29 Palms, and less than an hour after meeting PFC Wood, Ms. T calls her mom and says she would not be coming home, that she'd be spending the night in the Marine barracks in 29 Palms. Around 2 a.m., a group of 4 breaks off from the main group, and they go back to PFC Miller's room. And it seems that these were couples. There was PFC Miller and Shelby Martinez, and PFC Miller said that Shelby had tried to kiss him at some point in the night. And then there was the appellant and Ms. T. And once inside the room, Ms. T and Shelby are taking photos, they're checking their MySpace accounts, and Ms. T's asking for alcohol. And she and the appellant leave the room, and they go to look for some. But they come back about 5 minutes later, empty-handed. PFC Black said that the girl seemed to get more flirtatious as the night went on. And indeed, at one point, Miss T takes off her pants, and she's dancing around in the room to music with her underwear exposed. And she continues to ask for alcohol. The appellant leaves the room to go find herself, and he comes back with 2 cups, one for Shelby and one for Miss T, and they have Jägermeister and Dr. Pepper in them. And he gives one to each of them. At some point in the evening, 2 things happen. First, PFC Black enters the room, and he talks to Shelby, and he actually takes her back to his room where they have sex.
Counsel,
Yes, Your Honor.
did PFC Black testify?
He did not, Your Honor.
And what's this based upon?
His deposition, Your Honor.
Is that evidence of record, counsel?
It
Was
is, Your
it
Honor.
admitted as what exhibit?
That is defensive exhibit Delta, Your Honor. So this leaves only PFC Miller, Miss T, and the appellant in the room. At some point, Miss T goes into the bathroom and she gets sick. PFC Miller goes in there and he sees PFC Wood talking to her. They're having some kind of conversation, and he tells her that she could lay in one of the beds.
Wait, excuse me.
Yes, sir.
Are you saying that it was Miller's testimony that he saw the appellant in the bathroom with Miss T? Because I believe Miller says that he saw the appellant outside the bathroom when he went in there and saw Miss T on the floor.
Yes, Your Honor. In appellate exhibit 13 at 2, PFC Miller says that when he went in there, he saw Miss T hugging the toilet, and PFC Wood was in there talking to her.
What exhibit is that?
That's at appellate exhibit 13 at 2, Your Honor, where he says that PFC Wood was talking to her.
Well, Miller testified at trial, did he not?
Yes, Your Honor. This is an NCIS statement.
But he didn't testify to that.
No, Your
he
Honor.
didn't testify to the fact that the appellant was in the bathroom with Miss T.
Not at trial, no, Your Honor.
Okay,
At
thank you.
trial, what he testified was she was hugging the toilet and that he told her she could lie in the bed, and that's in the record at 175. And Miss T understood this. Actually, she got up on her own power, and she walked out of the bathroom, and when she did walk out of the bathroom, she asked for something to eat and drink. So at this point, she's communicating. She's able to walk on her own power. She doesn't need assistance of any kind. Apparently, there was nothing to eat in the PFC Miller's room, so they gave her a mango drink. The next thing that happens is PFC Miller leaves the room for a few minutes, and when he comes back, he sees the appellant and Miss T lying on a bed, and they're flirting and having a conversation.
Counsel, did he indicate they were flirting or that they were talking? He
Both.
being PFC Miller.
PFC Miller described them as having a conversation, and he said that it seemed like they were friendly and flirting, Your Honor. Now, after watching them on the bed for 10 or 15 minutes, and Miller did say that it was his opinion that Miss T was there to have sex with someone, after 10 or 15 minutes, he realizes that person's not him, and he wants them to leave the room.
Counsel, did he say he watched them for 10 or 15 minutes, or that he came back into the room and he originally estimated 10 to 15 minutes, but wasn't there a cross-examination question from the prosecutor where he acknowledged it was possible it had only been for a few minutes, maybe only 1 minute, that they had been conversing while lying on the bed?
Yes, Your Honor. The prosecution did, on cross, ask him could it be only a minute, and he said it was possible, but he thought that it was longer.
But that was based upon his assumption they had been communicating the entire time he was out of the room, correct?
You mean in the 10 to 15 minutes, Your Honor?
Yes.
I don't think so, Your Honor. I think that his 10 to 15 minutes, and his NCIS statement, which was taken very close to the actual incident, a year later when he testified at trial, I think his version was that they were there talking and on the bed for 10 or 15 minutes.
Was the NCI statement evidence at trial, counsel? Or was his testimony the only?
His testimony, Your Honor.
Okay, so his testimony at trial, he initially said 10 to 15 minutes, but on cross-examination, he acknowledged it could have been no more than a minute, correct?
He said it was possible, yes, sir. Well, at this point, PFC Miller tells PFC Wood that it's time for them to go. And PFC Wood goes over to Miss T and tells her it's time to go, and she asks why. Again, she's clearly communicating. She understands what's going on, and PFC Wood tells her because Miller doesn't want us in the room. They get up. She walks out of the room with the appellant. She doesn't need help. She's walking on her own. Again, communicating when she's asking the questions. And they go back to the appellant's room. And as PFC Miller said, she left the room while clearly conscious and understanding that she was going with the appellant back to his room. And once inside the room, Ms. T was an active, responsive, and aware participant in the sexual encounter that took place. She was kissing the appellant. She helped take off her underwear. And she helped guide his penis into her vagina. And the sex that ensued, again, she's a very active participant. She's biting and scratching at his body. She's kissing him, putting her arms around his shoulders. And she's enjoying the sex to the point of climax.
Counsel, where's the evidence that Ms. T helped put the appellant's penis into her vagina?
That is in PFC Wood's statement, Your Honor, which is...
Which of his two statements? He gave a statement on 10 July 07 and he gave one on 5 June 07.
Prosecution Exhibit 6, Your Honor, at 1.
Okay, go ahead, please continue.
Thank you, Your Honor. Now, on 2 occasions, the appellant actually took affirmative steps to ensure that Ms. T was still able, willing, sexual partner. He touched her face, he asks her if she's okay, and she responds affirmatively. She kisses him, she helps, she spreads her legs when he performs oral sex on her. And again, he's describing her as, and each of these, throughout the sexual intercourse, is biting at his body and scratching at his body and kissing him.
Counsel, you just omitted 2 important facts. Those 2 points that he says that ensured her awareness was after he noticed she'd fallen asleep, correct?
No, Your Honor. In fact, initially in PFC Wood's statement, first statement, NCIS, Prosecution Exhibit 6, his second statement, Prosecution Exhibit 6, which he actually went to NCIS to make, they didn't come to him. He says that she started to fall asleep. And then he describes what he did to make sure that she wasn't sleeping. And then later in the question and answer period by NCIS, the NCIS agent puts words in his mouth and says, "You said she fell asleep. How do you know this?" And again, regarding the second instance, he again says, NCIS agent, "How did you know she fell asleep?" That's
Well,
not what he said.
let's make sure we get this clear, Counsel.
Yes,
If you
sir.
look on page 3 of Prosecution Exhibit 6,
Yes, sir.
the question from the NIS agent is, when you looked down at her, what did you see? The appellant's response, "I saw that she had fallen asleep."
Yes, Your Honor.
Is that accurate?
That is what it says, Your Honor.
So that's the appellant's statement in response to the NIS agent's question.
Yes, Your Honor. But initially on page 1 of that statement, the appellant says, after a while, like an hour or an hour and a half, she started to fall asleep.
Counsel, on page 2 of that statement, they asked how long did it take her to wake up. He said about 5 seconds. In response to the second incident, how long did it take her to wake up? About 5 to 10 seconds. Doesn't that suggest that she was not starting to fall asleep, that she was in fact asleep?
Well, I think initially the appellant, it certainly suggests that, Your Honor, I agree. I think what clearly happened here is the appellant described her initially as falling asleep. The NCIS agent, who's asking the questions after PFC Wood comes to him and say, "I want to clarify to make sure all the facts are out," says, "You said she fell asleep." I don't think, as the appellant was sitting there answering these questions, he saw any difference. In his mind, he's thinking we're talking about her falling asleep. But even if she did fall asleep, Your Honor, when she woke up, she was an active, willing, and responsive participant. And we know that when she was in the bathroom, she would respond to the simplest of verbal cues. PFC Miller said, all you need to do is say, "Hey," and she would respond. And in fact, she did. She got up and left the bathroom and asked for something to eat and drink. And even if we were to assume that she fell asleep on the bed, again, she's easily awoken. PFC Wood asks her, or tells her it's time to go, and she says, "Why?" Now, she'd already thrown up, so whatever her level of intoxication was at that point, all it would be doing after that period would be going down. And immediately after vomiting, she's able to hold conversations. She walks on her own power. She's fully aware of what's going on and where she's at and where she's going and with whom. So even if she is falling asleep on these two occasions, her change in demeanor for 5 or 10 seconds in a 3-hour period in which the two of them are having sex is really irrelevant. What's relevant is her actions afterwards. And the appellant describes very clearly that they, not only were they having sexual intercourse, but he's stimulating her with his fingers, and he's also performing oral sex on her. And in each occasion, when the sexual encounter changes, whether it's the oral sex or back to sexual intercourse, she's responsive.
Except for the last time, according to his statement, on page 4 of Prosecution Exhibit 6, where the appellant in his Q&A with the NIST agent is asked, how did she look? Really sleepy? Did you try to put your penis back in? Yeah. Were you able to get it back in? Yeah. Then what happened? Lauren asked me to stop.
Yes, Your Honor. But
So on that last occasion, she's not a willing participant, is she?
Well, at this point, she, again, at that point, she makes it clear to him that she doesn't want to continue. But I think we have to look at the few moments leading up to that. As they're having sexual intercourse, Ms. T rolls to her side, and the appellant goes to roll with her, so they're going to have sex on their sides, or at least the appellant's belief is that. His penis comes from outside of her, and then he goes to reinsert it. At this point, she makes very clear, enough is enough. And quite frankly, after 3 hours of sex, that makes sense. Appellant even said that he did not ejaculate, and I think it's clear that at this point, Ms. T simply did not want to continue. And she made that known, and which is one of the reasons I think we can reasonably infer that the appellant was upset that basically he hadn't finished the sexual encounter and she wanted to stop, and he was mad when he left the room.
Let's focus just on the consent issue because obviously sex has occurred. What's the court to make of Wood's second statement? And I'll make it rated G. I felt bad because I know it was wrong to have sex with someone in their sleep.
Yes, Your Honor.
What's the court to make of that statement in the context of the consent or scope of consent she provided him at some point in the evening?
Well, I think that what the court should make of that is he had a concern for this girl that he had just met that night and was having consensual sex with. He wanted to make very sure that she was still able, willing, sexual partner. And for him to ask her if she's okay, and then for her to and to touch her face slightly and kiss her, and she responds by kissing him back, and then they engage in sex for another half hour, and
But she falls asleep again, and sequentially, he makes the statement, I knew it was wrong to do this to someone in their sleep. And then we got a couple more fall asleep, have sex, wake up, fall asleep, have sex, wake up events that follow that sequentially. Is that correct?
well, if we're saying that there were two instances in which her demeanor changed, which she may have fallen asleep, we'd agree, yes, Your Honor. I think the most important part, though, when we're talking about whether she fell asleep, and we're looking at it in the scope of 3 hours of sex, Your Honor, again, she's able to wake throughout the night at the slightest of cues. She didn't need to be shaken. She didn't need to be shouted at. Nobody ever testified that she was slurring her speech, that she was falling down, or anything of that nature. And even if this court found that for some reason Ms. T was incapacitated and couldn't consent, it would be reasonable for PFC Wood to think that she could. Everything he had seen up to that point indicated that this girl came to 29 Palms to meet with Marines, which they did. They were the only two women and 7 to 8 Marines. She then made her selection of those available Marines there, They went back to the barracks room, her and her friend Shelby.
Counsel, doesn't her testimony contradict that? She suggests that your client was actually, stalking is too strong of a word, but she used the word creepy, I believe, with respect to the way he was watching her. And maybe more importantly, you're omitting the fact that he observed her apparently while she was vomiting in the toilet and laying down on the floor in the bathroom after having consumed a substantial quantity of alcohol, correct?
Yes, Your Honor. Regarding whether she was creeped out in any way, apparently she wasn't that creeped out because she went back with appellant and her friend and the friend that she was and PFC Miller. So there's only 4 of them in the room. And quite frankly,
you seem to be asserting a mistake of fact, is what I just heard from you a moment ago, was even if we don't find consent,
yes, Your Honor,
there's at least a reasonable mistake of fact.
Yes,
here.
Your Honor.
Well, it seems to me we're talking about 2 things. Her state of intoxication and or incapacity brought on by the intoxication and or sleep. Focusing on the intoxication piece,
yes,
it's clear your client knew she consumed a substantial amount of alcohol and even acknowledges providing her with some alcohol, correct?
Yes, Your Honor, but we would disagree that it was a substantial amount. The 2 most important witnesses in terms of determining her level of intoxication were Ms. T herself and Dr. Lyons. And Ms. T, who not only was she consistent that she was not drunk, she was adamant. And it was very detailed that she didn't drink a lot, that she never finished the actual...
Did she get sick, counsel?
She did, Your Honor.
And were there indications from including Miller and your client that she appeared to be intoxicated or drunk? Words to that effect?
Yes, Your Honor, but I think we're talking about degree here. And I don't think the evidence is strong enough to say that she threw up because of her level of intoxication. Because if you remember, she was given this combination of Dr. Pepper and Jägermeister. And Jägermeister has a very unique taste to it. And she even described it as weird and dark looking. She drinks this and immediately throws up afterwards. Well, the doctor testified that it would take at least 20 minutes for the body to absorb that. So whatever alcohol was in that drink certainly wasn't going to cause her to bring her to throw up. More likely, it certainly can be inferred from the evidence, is that this drink, which she had never tasted before, simply disagreed with her and made her throw up, because very shortly after she's thrown up in the bathroom, she's up and about. She's purged the alcohol that she did have left in her by throwing up, and now is having conversations and walking freely and clearly aware of what's going on in the room.
Well, that's what your client says, but didn't she say that after throwing up she recalls throwing up in the bathroom, and the next thing she recalls is feeling your client having sex with her, and that was some period later, correct?
That's true, Your Honor.
And the trial judge actually viewed this witness, this alleged victim, on the stand, and after assessing her credibility, which is something we can't do on appeal, and concluded that your client was guilty beyond a reasonable doubt. So he must have made a credibility determination that what she was saying was in fact believable. What do we do about that, counsel?
Your Honor, this court doesn't need to view Ms. T to realize that she's not credible. The fact that she says that she did not remember anything from the time she threw up to finding PFC wood atop her is really irrelevant, because of all of the things that happened prior to that she says she doesn't remember, but we know happened. She doesn't remember coming out of the room and asking for something to eat or drink. She doesn't remember having a conversation with PFC Wood while she's lying on the bed, but we know that happened. She doesn't remember walking out of the room with PFC Wood and going back to his room, but we know that happened. And even the next morning, her memory goes blank. She doesn't remember some of the statements she made to PFC Miller in his room. She doesn't remember really anything that has any sexual undertone. So the fact that she doesn't remember or claims not to remember what happened once inside Appellant's room is simply irrelevant in this case, I think, Your Honor.
It's irrelevant. We have your own witness. There's a doctor who testifies that it's also very common for people who have consumed large amounts of alcohol to underestimate the quantity they've consumed, correct?
Yes, Your Honor. And again, she's not one of those people. This is a girl who had been drinking since she was 17 years old. She indicated that she drank not just 4 drinks on the weekends, but hard liquor.
Counsel, so what you're telling us is she lied at trial again. You're saying she's not credible because she doesn't remember, yet the individual who had the ability to assess her credibility was the trial judge. He must have found her credible. Wouldn't you agree?
Yes, Your Honor, but But even if we're certainly calling into question whether she was being truthful, Your Honor. But even if she was drunk, we still come to the question of whether she was drunk to the point of incapacity. And all of the evidence we have says that she knew what was going on and was aware of things. Again, because she's leaving the room, talking, having conversations. And if
Didn't the defense witness at trial, the doctor, testify that behavior would be consistent with the blackout?
Yes, Your Honor. And at that point, then the mistake of fact defense comes into play. And all PFC Wood was able to see was what she was doing. She never told anyone she was drunk. In some of the cases the appellant cited in his initial brief, any observable indicia of incapacitation simply wasn't here in this case. Even if we consider, well, she did throw up. Afterwards, everything she does tells anyone that's there that she knows what's going on. She's having conversation. This is what PFC Wood sees. He tells her it's time to go. She asks why, and the appellant tells her, well, Miller doesn't want us in his room. She clearly understands this, gets up and leaves with him. How would it be unreasonable for an appellant at that point to think that she didn't know what was going on?
Can you explain for a moment how your client had an honest and reasonable mistake of fact as to Ms. T's consent? Because you've raised mistake of fact a couple of times in your argument, and you also have it in your brief.
Yes, sir. I see I'm out of time, Your Honor.
You may answer.
I'm sorry, can you repeat the question, Your Honor? How he has a reasonable...
How he has an honest and reasonable mistake of fact as to Ms. T's consent.
Well, again, Your Honor, everything he sees up to the point that the last person that sees Ms. T and him together is PFC Miller. Miller says that she was clearly conscious when she left the room. And again, there was nothing that PFC Wood was observing that would tell him that this person didn't know what was going on. She was communicating. She's aware of where she's at. She's asking questions. She's hungry and is able to convey that hunger to others. She's drinking a mango drink in the room. She never had another drop of alcohol after she vomits. So again, if anything, her blood alcohol content is lower. And the doctor testified that someone who has a few beers can go to sleep and be awakened just as easily as someone who hadn't. And if she was falling asleep or even fell asleep at one time, appellant finds a change in her demeanor, and he wants to make sure that she can still consent and still wants to do this. So he touches her face and asks her, hey, are you all right? And she kisses him back. Then he performs oral sex on her. And again, she's spreading her legs. She's, from his perspective, enjoying the sex. So I don't know how it would be. I think that's how it's reasonable for him to be mistaken if he was, Your Honor.
All right, thank you.
Thank you, Your Honor.
May it please the court, I'm Captain Anneton, representing the government in this case. Appellant's conviction should be affirmed for rape because the evidence submitted by the trial counsel was factually sufficient to support the conviction for rape. The evidence shows that the victim was substantially incapacitated to the point that she could not consent, and furthermore, appellant was very aware of her state of drunkenness. The victim drank a significant amount of alcohol to the point where she vomited. The appellant was the one who provided her with that last drink that put her over the edge, that caused her to vomit. Appellant actually witnessed the victim vomit in the bathroom, saw her fall asleep or pass out on the bathroom floor. He was there, witnessed her get up and move to the bedroom, or to the bed in the room, and pass out again. His conduct here was anything but mistaken. He knew that she was drunk. He provided her with alcohol. He saw her vomit. When she was passed out on the bed, appellant kneeled over her, spoke to her. We don't know if he was flirting with her, but he spoke to her, and the only indication that we have is that he took her to his room. We don't know
Well, counsel, that's not exactly true. Miller testified that when he walked back into the room that the appellant and the victim were lying on the bed speaking to one another. There's some variance with respect to duration of that communication, but it seemed very clear from Miller's testimony that in fact they were communicating in low voices, which he could not hear because of the sound of music. But so she was cognizant and communicating. Miller also testified that she left the room under her own power after he asked her to leave, didn't he?
Yes, sir. But the important thing to note there is that she had fallen asleep on that bed. So whatever communication was there was during a point when she was so incapacitated that she was passing out, at the most mumbling.
Well, counsel, you're assuming facts here. You use the word passing out. What we know is that she and the appellant were talking on the bed in quiet voices, were asked to leave the room to go to an adjacent room. They actually got up and left the room. So you're saying she's passing in and out of consciousness. I don't read that in the record at all. It's clear that she was tired. It's very clear she was also under some influence of alcohol. But could you show me in the record where it says she was passed out and incoherent at the time Miller talked to her and asked her to leave the room?
Well, PFC Miller's testimony record at 177 and 181 that the victim was obviously drunk at that time. And he testified that he was the one that actually said, hey, move to the bed. And he testified that she did move to the bed and did fall asleep. If you want to call it falling asleep, an alcohol-induced sleep, or passing out, she was on some level unconscious.
So granted, had they had sex at that point in time, we may have a rape here, but that's not what occurred. They were then communicating. She and the victim and the appellant were communicating in quiet voices for some period of time, then asked to leave the room, and they in fact did so, didn't they?
Correct. And what's more important is that when they did leave the room, we can focus on the events that took place there, which there were only two people there, the victim and appellant. What's most important here is that in appellant's statement, he admits that the victim was falling asleep while he was having sex with her. He said that at one point that her body, she just stopped as if she quit. She was asleep. She was not conscious.
For 5 seconds. Are you asserting that 5 second period the first time or the 5 to 10 second period the second time is when the rape occurred?
He said that it took her 5 seconds the first time, 5 to 10 seconds the second time. When the victim was asleep, alcohol-induced sleep, that is when a rape occurred. So 2 times in this sequence of events.
So are you conceding that there's no attack on his statement up to that time, that there may have been consensual sex preceding her losing awareness for 5 seconds and then again for 5 to 10 seconds?
No, there's the government's position that at no point was the sex consensual. But pinpointing specific moments in time, the 5 seconds and 5 to 10 seconds that the victim was actually asleep, that is definitely rape. That's the government's position. But the government's not conceding that any sex that occurred before that was not rape either, because it's the government's position that she was substantially incapacitated at that point as well, and that the appellant knew that. He was a predator here. He provided her with alcohol. He saw her vomit. He saw her falling in and out of a level of unconsciousness that, based on what she was drinking, was alcohol-induced. He knew all these facts, and yet he still took her to his room, and while she was asleep, had sex with her. That is rape.
Let's talk about the standard we're under here. Are we inhibited in any way by our inability to see or hear the witnesses in this case?
No, you're not inhibited, Your Honor. You're actually, you're permitted to make allowances for the fact that you weren't at trial, and that the military judge was the one who was there. He saw the witnesses, he heard their testimony, and he was able to weigh their credibility.
But what witnesses did he see? He saw the victim testify that she doesn't recall anything from the bathroom to stopping the intercourse. What other witness testified as to what occurred between those 2 points in time?
You have PFC Miller, sir, and you got Lance Corporal Ryba. Those were the other 2 key witnesses here. And what they saw was they also testified that the victim was obviously drunk. Yes, she was.
Well, Ryba didn't testify to that. He didn't see the victim during that period of time, although he did acknowledge that she appeared drunk in the morning, the following morning. But during that time, he wasn't a witness to anything that occurred, correct?
That is correct.
He only saw the appellant enter the room.
That's correct. But that following morning, when Lance Corporal Ryba was saying that yes, had a blank look on her face and it seemed like she was still drunk. He did testify that he talked to appellant that next morning, and appellant said that he was also aware that the victim was drunk that previous night. So Lance Corporal Riva's testimony, again, that corroborates the victim's testimony. Lance Corporal Miller's or PFC Miller's and Lance Corporal Riva's testimony corroborates the victim, and that just goes to bolster her credibility.
One of the things that Miller says on page 177 of the record, he's asked a question, and she was clearly conscious, and he says, yes, sir. I mean, she was obviously drunk, but she didn't have to help moving from place to place or anything like that. Next question, was she making decisions by herself at that point? Answer, I would say so, yes, sir. How does that corroborate the victim's testimony?
Well, at that point, she doesn't remember anything after post-vomiting. How that corroborates the victim's testimony is that at that point, he is saying that she was obviously drunk. Yes, she may have been able to move.
He says she was clearly conscious.
Clearly conscious, but also obviously drunk. Just because she can walk and talk does not mean that she is not drunk, and it doesn't mean that she's not substantially incapacitated. Yeah, at that point, we're more going to the mistake of fact issue, which it's the government's position that it's not reasonable or honest for the appellant to believe that she wasn't substantially incapacitated because of the facts that the government has already stated. He saw the victim vomit. He saw her passing in and out of consciousness. He took her to his room after he saw her passing in and out of consciousness twice. And while he was in the bedroom having sex with her, she was asleep. She had fallen asleep 2 different times. And that's what the government would like the court to focus on.
Well, counsel, if we back up to the inhibition, as far as backseat driving the trial judge, we acknowledge that we have to make allowances for not having observed the witnesses. But if the alleged victim here's testimony was, I don't know what happened between point X and point Y, and the only other real evidence of what occurred during that period is a statement, or 2 statements that were admitted into evidence, are we inhibited in any way from, does that limitation on our ability to review the facts really come into play in this case? Or aren't we in a similar position to the military judge with respect to assessing the evidence that was presented at trial and determining whether beyond a reasonable doubt this individual committed these acts by force without consent?
Sir, you are in a position similar to the military judge. I mean, neither the military judge or you can have an opportunity to observe appellant testify, but you do have a statement, and in his statement, there's a government's position that it does flush with the victim. The victim says she doesn't remember up to a point, which that's the government's best testimony that she was in fact incapacitated. Now, since we don't have a testimony as to what happened in that room, and those were the only 2 people in the room, we have to focus on the appellant's statement. And in his statement, again, the government's going to point to his admission that she was falling asleep, that her body went still, limp, as if she quit, that she was not of sound mind. She did not have her mental faculties. And that's even further proven by the fact that he said when she did actually come to on that last time, her eyes opened really wide and she pushed him off.
But the 2 previous times he indicated that every indication she started kissing him and participated actively in the sexual activity. So we have effectively 3 incidents where he alleges she was losing awareness. 1, she recovers from in 5 seconds and, according to him, actively participates. 2, 5 to 10 seconds, recovers, actively participates. 3, loses awareness, eyes open wide, and basically at that point it's clear she terminates, and he actually, according to him, stops having sex with her, correct?
Yes, sir, that is correct.
So are you suggesting that she withdrew her consent, or that those brief periods of sleep constitute a technical violation of Article 120? His continued sexual intercourse during those brief periods of sleep?
Yes, it's the government's position that during those periods when she was actually asleep, that the appellant testified or admitted to, that is rape. And yes, you have to take into account there are inconsistencies, but reasonable doubt does not mean that the evidence must be free from conflict. And again, the government would like to take you back to the test. The military judge was there, he weighed the credibility, and he was aware of these inconsistencies, but he found appellant guilty beyond reasonable doubt. Because
that's my exact question from earlier, though. Normally, if this was a straight he said, she said, they both testify, give different stories, we owe great deference to the military judge because he observed them. In this case, it's not a he said, she said. It's a she doesn't know, and there's documentary evidence saying what he said. So we're very much in a similar position to the military judge, aren't we?
Yes, sir.
To effectively almost backseat drive. I mean, we get a second, the appellant gets a second bite at the apple on reasonable doubt to a great degree in this case, doesn't he?
To a great degree, and it's the government's position that this court should, even though this is a de novo review, should defer to the military judge's finding of guilt.
Well, we don't have to defer to his finding of guilt. We have to defer to his ability to assess credibility. But I think haven't we already established that the credibility of the victim with respect to what occurred after she vomited into the toilet and until she awakened, she doesn't have a story or an explanation or a recollection of what occurred in that intervening time frame.
That's correct. She does not have any recollection from the period in which she vomited until she woke up to the appellant having sex with her.
And the appellant's statements, he clearly didn't take the stand. So there was no credibility call other than within the statements themselves, and there are clearly some inconsistencies. But we can assess that as well as the military judge, correct?
Yes, sir.
Second question, I don't mean to change gears too far. Are you effectively conceding that mistake of fact was in fact raised at trial? If in fact this were a member's trial, would the judge have had to have instructed on mistake of fact?
Yes, sir. And I mean, in the defense's closing, he definitely, at the very least, inferred to mistake of fact.
Your pleading suggests that the defense bears some burden with respect to mistake of fact. Or if the mistake of fact was raised, who had the burden of proof and by what, and what was that?
Sir, that was a mistake on the government's part. The burden is on the government to disprove the mistake of fact beyond a reasonable doubt. That is very clear. The government apologizes for that. But again, taking us back to the core is that appellant in this case, again, he provided the alcohol. He saw her vomit. He saw her passing out. He admits to having sex with her while she was asleep. He's a predator in this case, and he admits that by saying he had sex with her when he fell asleep. He said at one point, "I know it's wrong to have sex with somebody while they are sleeping." That is an admission. He said he was having sex with the victim while she was sleeping. She was substantially incapacitated. That's clear from the record. And it is not honest. It's not honest or reasonable for the appellant to have thought that she was able to consent.
But you're talking about his subjective belief on her ability to consent, or are we talking the objective? Which standard are we applying here with respect to what wasn't reasonable in this particular circumstance with respect to the mistake of fact defense? Are you saying his belief at the time wasn't subjectively, or that he didn't believe that?
It's not that he didn't, it's that objectively is not. Okay. It is not reasonable to believe. Unless there are further questions on the factual sufficiency issue.
What are we supposed to make of the fact that the next morning, after, as you've described him, the appellant as a predator, raped the victim, that she confronted him in the catwalk, talked to him privately? Is that something that normally a rape victim would do?
The government doesn't want to speculate on what a rape victim would normally do. But in this case, it could seem odd. But we have to take into account that the victim, she was stuck where she was. She was hungover, which is testified by Lance Holriver. She appeared that she was still drunk, incoherent. She didn't really know what was going on. She went to try to find her buddy, her partner, who she came with. Her friend said she wasn't ready to leave. So where else is the victim to go? She can't go.
She has nowhere else to go but to go and talk to the appellant?
Well, no, she is in his vicinity. And being in his vicinity, yes, she encountered him. And yes, engaged in a conversation with him. And it was a short conversation.
Yeah, well, one of the questions in that conversation was her asking him, "Did you use a condom?"
Correct, sir.
What's the court to make of that? Is that something a rape victim asks her rapist, or is that something that someone who's had unprotected sex and let their inhibitions down might more likely ask?
That's a question from a victim who has been raped. There's nothing she can do about it now. She wants to know what else she has to worry about aside from the fact that she's just been raped. She needs to know if he used a gun, because she doesn't remember. That even goes more to prove the point that she was incapacitated. She has no clue what happened until she woke up and saw the appellant on top of her raping her.
Okay.
She has to ask him.
Fast forward a couple of days from that. Why go to a place like Planned Parenthood versus a police department? Is that not a pregnancy counseling, sexually transmitted disease counseling location as opposed to a law enforcement victims service type of place?
Yes, that is more of a sexually transmitted disease type of a clinic. Is the court's question, why didn't she report this to the police?
We just see activity post-rape or post-sex that are consistent with concerns about pregnancy and STDs as opposed to reporting of the underlying offense. The victim, she made it very clear why she didn't want to report it at first. She said it was she was afraid of embarrassment. She didn't want her mom to know. She didn't want her mom to break her heart. That was her decision to, at that point, to not report the rape. What appears from the record is that she was more concerned at that time with her own health, whether she did have an STD or whether she was pregnant, and that's a valid concern from any rape victim. Just because she went to Planned Parenthood first does not indicate that she wasn't raped or that she didn't feel traumatized from her rape.
Counsel, I'm sorry. Were you finished with that?
Yes, sir.
Okay. Backing up to the morning after the event, what about the statement to Miller? And again, I'll use the G-rated version here, but about being about her willingness to have sex with just about anybody that night, based upon her level of intoxication. How does that factor into our assessment of the evidence here?
That statement doesn't go to prove that she actually consented. There's the government's position. That statement goes more to show exactly how incapacitated she was, that she really did not know what was going on.
Isn't another similarly reasonable conclusion to draw that actually supports the appellant's mistake of fact defense? She's acknowledging that she may have been aroused or arousable that evening based upon the way she was feeling that night?
Potentially, but the government would like to draw this court's attention to Appellate Exhibit 4 at 12, in which it was very clear that she was very serious about not knowing what was going on that night, and that statement was not made to suggest that she consented. It was more made to suggest that she had no idea what was going on and that she was actually that potentially incapacitated and didn't have the mental faculties to discern what was going on. And the government would just like to really draw this court's attention back to, it's not, in this case, it's not what happens after. It's what happened on that night, on the night in question, in the room. It's about the fact that appellant had sex with the victim while she was substantially incapacitated. He was aware of her level of substantial incapacitation, and he had sex with her while she was asleep. Let's not focus on what happened afterwards. Let's focus on what happened that night, which is the rape, and that's what's important in this case.
Well, you're focusing back to his statement. Let's assume for a moment we believe there's consensual activity prior to her losing awareness. You're still asserting that those brief periods of loss of awareness would constitute a rape, correct?
Absolutely, sir. That's the government's position.
Do you have any case law to support that position?
Well, there's U.S. v. Sizemore, in which the victim, she had drank a significant amount of alcohol, vomited, became sick, went back to sleep off the effects of the alcohol, fell asleep, and was raped by appellant.
But we can't take portions of the appellant's statement in isolation and focus solely on them without considering the surrounding circumstances. According to the appellant, there is consensual activity. She loses awareness. He senses it. He re-engages, he touches her, effectively, I think, along the face. She responds and then actually continues to participate. A while later, a similar activity occurs. Again, we're talking 5 to 10 seconds, and according to the appellant, a sexual encounter that lasted for hours. So we've got, at best, based upon the appellant's statement, 15 seconds of asleep in intercourse, according to the appellant, that went on for in approximately a 3-hour range. And you're asserting that that equals rape.
Even it doesn't matter if it's 5 seconds, 15 seconds, 30 minutes. When that victim was unable to, when she was asleep, and it's the government's position that sleep was brought on by alcohol, by her consumption of alcohol, she was incapacitated at that point. She did not have her mental faculties. 5 seconds, 10 seconds, that is rape, sir.
In Sizemore is a sleep case.
I apologize, sir. The government misspoke. It's Smedley.
And does Smedley talk about a situation where we have consensual activity, abbreviated period of loss of awareness or sleep, and consensual activity?
There was in that case there was sexual activity. In the first instance, appellant put his fingers in her vagina, left the room, came back, and then entered her with his.
But she was sleeping, correct?
Yes, sir.
Yes. I mean, we have a distinctive set of facts here where we have effectively lengthy periods of intercourse interrupted by very brief periods of loss of awareness or sleep.
Sir, the government only brings up that case to point to the fact that the court in Smedley found her to be incapacitated while she was, for the sexual activity that took place while she was asleep. Similarly, this court should find that she was substantially incapacitated, did not have her mental faculties while she was asleep. Just focusing on that point of it.
I mean, I think we'd all agree that if she was in fact asleep when the intercourse occurred, she can't consent. But again, under these facts, the best case you've come up with is a case where some limited activity occurred, then he came back and engaged in intercourse while she was sleeping. Do you have any other case laws?
No, sir, the government does not. But the government would say that in these types of cases, in these rape cases, regardless of the case law, factual scenarios, you have to take this as a case-by-case basis. And while the government does not have a specific case on point that is exactly like the factual scenario in this case, the government stands firm on its position that when she fell asleep, when the victim fell asleep, 5 seconds, 10 seconds, 15 seconds, that is rape, sir.
You're saying the moment that she fell asleep, if they were engaging in consensual sexual activity, what the government is saying is that the moment that the victim fell asleep, the appellant was immediately guilty of rape.
That's the government's position here. But the government would like to be clear on the fact that rape took place. That was not the only moment of rape in this case. We're just focusing on that point.
The government's position is the rape took place the moment sexual activity commenced.
Exactly, sir. Exactly. The government would like to be very clear with that. The rape took place immediately because she was incapacitated, and appellant knew that based on the fact that the things that the government's already argued: the vomiting, the passing in and out, and him witnessing it.
Counsel, again, I think we'd all agree this is a close case. This is not an ideal set of facts for either party. We recognize that, but the consistency of the appellant's statement with what he said the next morning, would you not agree that at least it looks like you use the word predator? You have predatory activity, and then you have some rather ungentlemanly comments the next morning regarding her activity during the sex, which preceded any report by this particular accused. Would you agree that seems relatively consistent with the story he told? Meaning the appellant's story is actually, there's some corroboration, if you will. Predatory behavior, clearly she's under some degree of influence, clearly he's taking advantage of the situation, and clearly the next morning he makes some very ungentlemanly comments with respect to her activity during the sexual activity, correct?
Yes.
He talks about her scratching his back and other things.
Well, he did say, he commented on her legs being hairy, and he commented on the fact that she hadn't clipped her nails. That doesn't tend to disprove the fact that what he did was rape, sir. I mean,
but it does seem relatively consistent, doesn't it, with what he says occurred during the night?
About her clawing at his back, sir?
Well, his story was that it was consensual behavior. The next morning he's making a joke about some of her activity during the behavior. Doesn't that not seem somewhat consistent with what he says?
the government is a little unclear here. When he was making his comments the next morning, he wasn't poking fun at her activity during sex. He was just commenting on her grooming, not what she was doing. He just said, "Hey, your fingernails are long and you haven't shaved your legs."
And she acknowledged that angered her, correct, when she heard that, as did him saying he didn't use a condom?
Yeah, she said, I don't care what you think, but again, that's, while it may seem to corroborate his story, that does not prove whether or not she consented to the sex.
Okay.
What's the government's position as to assignment of error 3, as to what remains from that? The court has granted 2 consent motions in the last couple of days before coming on today. What's the government's position? Are there any outstanding issues you'd like to be heard on with regard to assignment of error 3? And the Brady violation with regard to photographs or testimonial evidence favored?
Yes, sir. The first point would be, was there non-disclosure in this case? And based on the government's own affidavit, obviously our answer is no, there was not, that the photographs were disclosed. Now, obviously the government is aware that appellate defenses submitted an affidavit from the defense counsel saying that they didn't receive it. So even if this court were to find that there was non-disclosure on the government's part, the next question is what is on? Was there a reasonable probability that the outcome of trial would have been different had the photographs been disclosed? And the government's position there is no. There is no prejudice by these photographs having not been submitted. But that is just an alternative. It's the government's position that yes, these photos were disclosed, and we have the affidavit to support that.
To be clear, the second motion, which was ruled on from the bench this morning by Senior Judge Vincent, does not state that the defense did not have the discovery. It states in the alternative that trial counsel, under penalty of perjury, states that they did in fact provide the exhibit.
Correct, sir.
Okay.
That's the government's submission of that affidavit from the trial counsel, who was at the time Captain Jam. So yeah, it's the government's position, and it's a strong position, is that those photographs were in fact disclosed to the defense counsel.
Thank you.
Unless there are any further questions, the government has nothing further.
Thank you. Counsel?
Thank you, Your Honor. Your Honor, first regarding the appellant's statement regarding ensuring that she wasn't sleeping while he was having sex with her, I think the court really needs to consider that this is not a legally sophisticated or savvy person, that when he was talking about that, what he was explaining to the NCIA agent, and what they probably should have questioned him more to amplify his answers, was that he knew it was wrong, and therefore he had to make sure that she was still consenting. And if she did fall asleep for these brief periods of time, or was falling asleep, at that point, the appellant had 2 choices. He could have stopped, or he could have asked her, and when I mean stop, he pulled his penis out of her, or he could have asked her, as he did, was she okay, was she still willing to consent? He chose the second option. And it's important that in the first instance, in the second instance, he actually took his penis out from outside of her. And the first one, he didn't. He simply looked down, he asked her if she was okay, within 5 seconds she responded. So it would be absurd, as the government asserts, to find that as soon as her demeanor changed, or if she was somehow incapacitated or sleeping, that at that moment the appellant was suddenly guilty of rape. In this case, it really doesn't matter whether Ms. T was drunk or not. It's about the degree of her drunkenness. And Lieutenant Colonel Lyons talked about that when you're passed out, it's like being sedated. You don't wake up and pass out again, wake up and pass out again, wake up and pass out again. That's not how it works.
But everything Lyons talked about clearly was an extrapolation based on self-reporting of the victim, correct?
Yes, Your Honor.
There's no toxicology, there's no physical evidence whatsoever. He's just saying that if her rendition of how much she had to drink and her height and weight stats would yield a particular toxicology result as an abstraction, correct?
That's right. But I think it's important also to note that he even went further and estimated if she had drank almost twice as much, 75% more, that she still would have been nowhere near either blackout or pass out levels in this case. And there's no evidence that she actually drank 75% more. In fact, the evidence suggests that she drank less, because she continually said that she never finished the drinks she actually had. And it's important too that, even if she doesn't remember, amnesia does not mean lack of consent. A blackout does not equal lack of consent. And the Court of Military Appeals recognized that in Baran, that simply that alcohol can affect someone's inhibitions and it can cause them amnesia, but it does not mean that they do not have volition. They can still be willing to participate and not know it.
But can't we also look at the time that, it's a pretty dour moment when someone is passed out on the floor of a bathroom of a stranger. Is that not indicia of extreme intoxication or illness that raises the issue of incapacity to get consent?
We may be able to take that inference, Your Honor, but not the burden that's here beyond a reasonable doubt. The record, P.C. Miller said when he went in there, he didn't mention initially or at trial her laying on the floor. He said she was hugging the toilet. That suggested she was simply throwing up, and then she got up and came out. So we may be able to make an inference, Your Honor, but before we convict someone of rape, cause them to register as a sex offender for the rest of their life, the burden is much, much higher, and that's beyond a reasonable doubt. And the evidence just doesn't get us there in this particular case.
You've just got a minute left, and I'd like to ask you the same question as the government. What is the appellant's position now as to assignment of error 3 regarding the Brady violation and testimonial evidence in light of the two motions granted? Is that still a viable assignment of error, and if so, in what regard?
Yes, Your Honor. I think we have dueling affidavits here now, so that I think is an issue that would potentially need to be resolved. I think initially, first, the photos don't show us anything, the ones that we have. But if the prosecutor submitted the affidavit, Captain Jana Majal, if she gave these photos to the defense, then she should have copies of them that are clear that the court could actually look at and evaluate. Our position is that those photos are exculpatory. We can't tell from the photos as they sit now whether they are or not. So I think we would need, we want those produced.
Counsel, how in the world do they negate the guilt of the accused? They purport to reflect bruises. But whether they do or don't, how is that exculpatory given the facts we have in this case?
I see my time. Can I add to
Please.
it? Your Honor, bruising would be consistent with 3 hours of consensual sex. What's not consistent, though, is someone having sex with someone who's incapacitated for 3 hours. So the fact, if there is bruising in this case, it shows that she was consenting to it during the entire period. That's our position. And it's for the trier of fact to determine, to give them what weight they would give to those photos. But 3 hours of sex while someone is incapacitated is simply not a reasonable inference we can take. So it was certainly, these photos with the bruising present would certainly lend credibility or bolster the appellant's statements, and it would bring into question whether Ms. T's statements about either not knowing or not consenting.
The other part of your motion on the second assignment of error dealt with the victim's father's testimony. Did the government notify the detailed defense counsel and the appellant prior to trial that the father was a witness they were going to call?
Your Honor, it's not clear from the record, but at this time the appellant would concede that that's not an issue.
Thank you.
no further questions, that concludes my rebuttal.
Thanks very much. The matter's been submitted. Thank you, counsel, for excellent arguments.
All rise.